how do you find out whether what you are doing has a potential to obtain a patent right from any government? So before we delve further into the subject, I would like to simply walk you through the patents. I mean, a little basics, and then we directly jump to at judging the potential of your own product for obtaining patents. Now, patent law, patents, you must have, I mean, since you're in science and tech, you must have heard of patents. So patents are the last legal monopoly left in this world, to be honest, because after antitrust law, competition law, you know, you're no longer allowed to have a form a cartel or have a vertically integrated industry structure is also frowned upon. Like you are also developing raw materials, you're also developing finished goods, you're also transporting them. So it's your monopoly all across. So that is also not encouraged in many countries. But patent law remains very much a legal monopoly, which allows you to preclude others from using your invention. Okay? If you have invented a new product or process and you do not want anybody else to use it without your authorization or permission, which is also called as license, uh, that's where patent law comes into picture. That's where you try and obtain patent rights for your invention. An invention could be in a product or in a process. All right. Now, why do we file patents? We file patents primarily to stop others from practicing your invention. All property rights are negative. If somebody encroaches, if you own a plot of land, that does not mean you're free to do whatever you want to do with that plot of land. If it's in residential area, you can only build a house there. If it's in commercial area, you can only build a shop there, right? And if it's in an apartment or a condominium, that apartment cannot be turned into a club. It can only remain a house, home, right? So, but what right does a tangible property right gives to you? It stops others from living in your property, from encroaching upon your home, from encroaching upon your shop without your permission, which you call rent. Okay, you charge rent for somebody to use your own property. Same way is the patents. Patents are to stop others from using your inventions. Nobody can encroach upon your product or process without your express permission. Otherwise, they will face damages, penalties, lawsuits. Their product may be mostly the product is sealed, and the court will say you cannot sell the goods anymore because you're infringing this patent. This is the primary uh, aim or objective of filing a patent application. Okay, consider patents as sort of uh, insurance, like a mediclaim. You pay for it, and you hope it keeps it's there because you never know when a calamity will strike you. As far as mediclaim is concerned, similarly in business, you never know which big business will take over your product or process and start selling it. Okay, you are a startup. You started with a new invention, new product, and then there's this new big company, big corporate, who has all the muscle, both human as well as financial, and they just push you out of the market. So patent law are working on the periphery. That's where they will help you. All right. So patent law will help you guard yourselves against a big corporate as well as your corporates of your own size. Okay, that's why in this intellectual age, when many people are working in co-working spaces, you don't need a huge factories, and most of the stuff is done contract manufacturing manner, right? All you possess are intellectual property rights, and most importantly, patents. Okay. Now, patents allow you to license or sell your product or process. Okay, you can always license it or sell it, rent it out basically, and earn royalties from it. Having patents in your CV gives you a favorable image, prove that you have penchant for being an inventor. You definitely gain recognition for novelty and problem solving, And when once you have a patents, few patents, especially in US, Europe, I mean, that impresses colleagues and your peers as well. Okay, so that's why we file patents. So for startups, we want to file patents mostly to stop others from using your invention while you develop your product. You don't need to worry about, oh, I have disclosed this to my product to this particular VC, or I have disclosed this to this particular conference or this particular government body. You don't have to worry about it if you have filed your patents properly. All right. Now, patents are granted on certain fixed criteria. There are four criteria mostly, but these three criteria are quite uniform. So you must cross the test of these three criteria before you can obtain a patent. Okay, that's how you will understand the patentability potential of your product. Okay, so now we are going to the subject at hand, how to determine patentability potential. Okay, so first of the criteria of obtaining a patent for on your product or process, that it should be absolutely novel. There should be no disclosure at all anywhere in the world. Anywhere in the world. So the novelty is adjusted by global standards. It's adjusted against global obligations. Okay, and it need not be a patent. The disclosure or the publication need not be patent publication. Okay, it can be any kind of publication. Okay, it can be general internet search, it can be a web page, it can be a book page, it can be a book itself, it can be a research paper, it can be a magazine. If there is any publication of your product anywhere in the world, in any which format, this criteria you are not fulfilling. Okay, that's you are not novel anymore after that. Okay, that's you get defeated. So your product cannot go further in the test. You have already you have not crossed the first level of check of patentability. Okay. Now, how do you determine novelty? Novelty को determine कैसे किया जाए? How do you determine novelty? How do you set the criteria of novelty? So you break down your product into several features. For example, you say, okay, I have developed an electric vehicle, and that electric vehicle can generate energy from 2 or 3 means. It has a turbine, it has a solar panel, it has a regenerative braking. For example, there are 3 different means, all put together in one bike. Now, these are the features. So you will break down your bike, a bike having these 5 features. So you are looking for a disclosure that exactly discloses a bike or a vehicle with these 3 things put together in one go. If they are present separately, like one bike is only solar powered, another is regenerative braking powered, another is wind powered, then you fulfill the criteria of novelty. Okay, then you don't have to worry about I'm novel or not. Do you understand? So novelty is determined by taking all the five. If your product has 5 features, those 5 features of your product must be published together in the same context as yours. Okay, or in the similar context as yours. If that's not the case, out of 5 features, only 4 are published, one is out of the picture altogether, then you at least will qualify the criteria of novelty. Okay, so that's how we do the legal test of novelty. That's a way of conducting a legal test of novelty. Next criteria of patentability is determining inventive step. Now, this is a very legal, technical examination. It comes to you over the years of practice as a patent attorney, but being an inventor also, you should rather, as an inventor, you might be a disadvantage to appreciate the inventive step in your own product. Okay, because inventors come with a lot of hindsight, and this happens with a lot in academia, even in industry, MSME. They think that, oh, this is a shop floor improvement, and this is not patentable. So they let go of the patents, and then they find out, oh, everybody is making this product or using this process, and then that's where the regret marches in. They feel that, oh, they could have actually protected it. Okay, so at being an inventor of your own product will put you at certain disadvantage at appreciating the inventive step of your own invention. If the product is an incremental improvement, okay. So now you have non-obviousness inventive step is true. Somebody has raised hand. I think we can take questions later. Non-obviousness inventive step. Now the invention after you have fulfilled the criteria of novelty, that your 5 features put together in one product are absolutely new. Okay, that means you have already passed the first test. Now the turn is the second test. Is combining these 5 features in one product or process, is it obvious or not? Are you solving a technical problem or not? If yes, then there's an inventive step. Okay, if it's obvious to combine solar powered battery with a regenerative braking battery, then there's no invention, there's no inventive step. You may be new, your bike may be novel, but it may not be inventive. But now, for example, you make possible to have fuel cell, hydrogen fuel cells. You miniaturize it to the extent that it can power a bike in the acceptable speed limits of a city, and that means that may be an invention. Okay, that's where you're solving actually a technical problem. You're solving a technical problem. So that's the second test of non-obviousness or inventive step. All right. So usually the approach we use in legal while we are arguing before a patent office is problem solution approach, where we say that this is a problem identified by the inventor, this is our solution, and how this solution differs from the other competing references that have been cited. So when you do your own patentability assessment, first step you will do is determine the novelty by finding out all the references. So you have now 10 references, 10 close references. Now you have 10 close references with you, right? All those close references do not reveal any disclosure, any product or process that have all the 5 features or 3 features, whatever number of features you have in your product or process in one go. So you have your novel. Then you keep these references close to you, and then you do another inventive step test. Then you see whether my combination has at least been hinted. There may be a hint. Somebody wrote a patent on solar bike, and they say, oh, it can also be wind powered by wind energy. That's it. That hint is good enough to kill the inventiveness. Okay, but if you enable a hint, like somebody saying a bike can be powered by wind energy, while you yourself actually developing a turbine which works very well with the aesthetics, and it doesn't look bad, it doesn't look ugly, it's not heavy. So you have worked it out very well within the chassis of your bike. There may be an invention. Okay, so you may have an invention at hand. So that's how you determine the second test of non-obviousness. You have to, being an inventor yourself, you have to take a step back and see if something like that really existed. Any document really hinted at what you have done and how you have done it. If no, most probably you will clear the second criteria as well. All right. So startups must know. Startups founders, you can do this basic check at your level before, because at times you will have 10 to 12. You're working on different one product, and it will be compendium of 10 to 12 inventions. Going to a patent attorney for 10 to 12 inventions is going to be costly to do a patentability assessment. So you can do this out of 10 or 12, you can filter out all the ridiculous possibilities yourself. Okay, and if you find out 2 or 3 which you feel are novel and inventive, then you invest money in that and get a proper opinion. That's how we recommend all our startups to start to learn and appreciate the technical and legal side of your own technology. Okay, so that is the second criteria. Now the third criteria of patentability is industrial utilization. Every invention must be capable of being used in an industry by way of product or process. The word use here is written for Europe and US. In India, you do not get a patent on use. Okay, if you find out a new use of an existing medicine or drug or a machine, like this machine was used for harvesting wheat, I modified it, now you can harvest rice, that doesn't work. Okay, And so use is not patentable in India. India will only allow patents on process or product. Okay. So the third criteria of patentability, which every patent, every invention nearly fulfills, is that it's capable of being used in an industry. Okay. So these are the criteria of patentability. These are the three criteria, main criteria of patentability across the world. All right. Now, I think I will, before I overload you guys with information, if you have any questions on this criteria, these criteria, please feel free to ask now. Because the session after this is going to be a bit more intensive and bit more technical. So it's all right to settle some doubts if anybody has right now.
So I want to ask one question. Hello.
Sure, sure, please.
Yeah. Now suppose the now students want to have done something new product. Now he is presenting that product and the exhibition. So all the people come to know there. No. So you said like you should not be putting on public media or something like that. But a
Yes.
student, whenever he's going with a project, he'll put it in front of all, like and all the children will see that.
Yes.
So and
See,
if they take the photograph and put it on the Google or something like that.
that will potentially kill your patent.
Yeah.
That will potentially harm your patent. That's why we always tell academia to, if they feel something worthy, they should first file a patent and then go for publications in conferences or in journals.
Okay.
Okay?
Okay. Okay,
Okay?
sir. Thank you.
Yeah. All right. Any other questions? Any other question? By anybody? Please feel free to ask. Being patent attorneys, we ask very ridiculous questions from our clients, startups, MSMEs, big companies, because that's how you get the best technical information. So please do not feel shy. Ask anything.
Hello.
Hello, yeah?
Sir, if I understood correctly, the product qualifies for novelty even if it is an assembly of 5 features. Assuming it solves a technical problem, but one or more features are a reproduction of existing technology, but others are not, could it still qualify as patent?
If it solves a problem, and you come again, you're saying one of the features is the
Reproduction of existing technology,
okay,
but others are not.
and others are not. And then you're saying, and there's a patent application which, there's a publication which already anticipates it, which already discloses all the 5 features.
Yes, there are 5 features in this new product, but
Yeah.
one of them was a reproduction of existing technology.
So when you reproduce it, did you alter it?
Alter it may be minor change.
Maybe a minor change. See, that's where it depends on the degree of change. Okay. For example, you can say, okay, this product was this particular machine was heating up and was melting. So I made it of iron. That is one of your features. Okay. So now it's not gonna melt at least. Or I have added a fan to relieve it of the heat. So these are the shop floor features, shop floor invention. This amount of change does not qualify as inventive step. Okay. But if you change it substantially, that solves a technical. See, the technical problem of heating is already known how it can be solved by creating air sinks, by putting a fan out there, by using a water jacket. These are the same standard means of, say, tackling the heat, right? But if you employ some other mean of tackling the heat and say it's also generating energy, that is where you have created a new invention. Am I clear? If you
Okay.
can give me some specific example, it can be more clear.
If
But
I
always remember,
if I say
increment. Yeah, come again. Yeah, yeah.
instead of say iron, if I choose to use mica, which
Hmm.
is more heat resistant,
Yeah,
will that
yeah.
qualify?
No, it won't, because mica, the property of mica is not your invention.
Okay.
Mica has provided this particular feature by its own inherent property. Okay, it doesn't come by your arrangement of different material or your different like creating an air sink out of mica, right? So where the heat sink out of mica, something like this.
Or
That's
if
where
I
you can
create a
see.
completely new alloy,
Then you have a patent. You create completely new alloy to tackle the heat problem. That's a patent. That's a composition, a product patent for you.
thank
And
you.
And then we will not restrict your alloy only for tackling heat problem. We will just call it alloy and you can use it to make vessels, utensils, or even parts of vehicles, bikes, who knows. So the patent's scope will not be restricted to only as a heat tackler. Okay, it's just a metal alloy and can be used as all metal alloys can be used in different application areas. Okay.
Okay.
All right. So it
Hello,
depends
I
on the
have a
degree of
question.
change. Yeah, please.
Hello, yeah. If one comes up with an idea which is an original concept in the way it does whatever it does, and if that concept is patentable, so you go ahead and patent it. So then once it's patented, should one also file a design copyright?
See, you must understand how the purpose of design and
Yeah,
patent law is very different.
yeah,
Okay. Now consider there is a water filter. Okay. A water filter is usually kept inside a box, a dome, a plastic body, right? And you can have that plastic body of any shape and aesthetics. But the water filtration mechanism that you have invented is inside that body. That is not visible to anybody. So this technology of filtering the water actually is patentable. Okay, that qualifies for patent. All right. Now this mechanism can be put on an industrial scale using big towers and everything. It can be done at a home scale and a small aquaguard type of product. But the outside of the product, the aesthetic, the appeal, the visual appearance of the product is protected by design. Design does not protect the technology. Okay?
okay,
Design merely protects the visual appearance of your product. So if you have developed a water filtration technology, first you file a patent on it. Okay? Then you say, okay, I'm gonna make this water filter in shape of a glass with a handle. So this handle will have the cartridge and everything, but it will look like this, so that it's very appealing. It stands out in the market. You have so that's where you file a design application
Mhm.
only for visual appeal. So anybody who sells, so now somebody in the market is not using your water mechanism, your water filtration mechanism. They're not using your water filtration mechanism, but they are copying your design. You can still sue them.
yeah.
Okay, so you have protection on the two front now, tech front as well as the design front.
Yeah. So
Okay.
I understood that now. Thank you. And there's one other query is that suppose that I had filed a patent for a product some few years ago. It's not done too well, but any which way, the product was so simple that all the elements that I used for filing that make the product patentable are the same as the design only. Exactly the same. I didn't have to change anything else to now make a design out of it because it worked as a product because of the way it was made, which is so bare minimum.
Okay.
So,
Okay.
so I
See,
never filed a design
see,
copyright. So I was wondering whether one should file it or not file it then.
sometimes it happens that your design is a reason of your function, of your improved
Yeah,
function, right? It
yeah,
happens. It happens many a time. So always remember, if your design has a functional importance, a functional significance,
yeah,
and it has a function in itself,
yeah.
you must file a patent. Design will not protect you good enough
Okay.
at all.
No, we filed a patent. We didn't file the design
Yeah,
copyright.
I think that is good enough.
Okay, that's fine.
If your design serves the function, then you file a patent. It's broader protection. For
Yeah,
example, I give you an example. For example,
yeah,
there is a cup. All the cups in the world have no handle. Okay,
yeah,
you come up with a cup with a handle,
mm,
right? It's a C-shaped
yeah,
handle attached to a cup,
mm,
right?
yeah,
Now you when you go for a design application, you will only protect a cup with a C-shaped handle. That's
yeah,
the scope of design protection. When you write a patent on it,
mm.
right? You will say anything, any any handle, for example,
Container. Yeah.
any handle projecting out from a container is your invention.
Mm.
So it can be
Yeah,
C-shaped, it can be B-shaped, it can be a straight line to hold a cup,
yeah,
basically, right? So
got it.
patent
Yeah,
will expand the scope of your protection. So even though
yeah,
you invented only a C shape, but you realize it can be any shape handle, right? So
Yeah.
you cannot go on filing design for all the shapes of your handle.
Yeah.
So best is to protect it as a
Exactly.
patent. Okay.
Okay.
Yeah.
Yeah. Yeah. Thank you. That answers my question pretty well. Thank you.
Thanks. Any other question?
Sir,
Because yeah.
so going back to that alloy question,
Yeah.
sometimes the difference could be a minor change in composition itself could alter the chemical properties significantly.
Yes.
So even then it qualifies as a patent.
It does. There is a doctrine of surprise results. See, as you delve further into inventive step, in judging inventive step, right? You have to, you will you will be familiarized with several doctrines that come into picture. Now, there is a thing called doctrine of surprise results. If a minor change in composition completely alters the property, that is a surprise result that has been obtained, and nobody hinted it anywhere, right? That's where you have an invention. It happens very frequently in nanoparticles. Now, nanoparticles are regular particles at the size less than 100 nanometer. Okay, but you will still get patents on. Reason being that nanoparticles, the same particles at size less than 100 nanometer, exhibit totally different properties. So, in your patent application, you write something is happening on the screen. Okay, on your patent application, you write that you want to claim a nanoparticle of a certain size. Okay, so nanoparticle is the biggest example for a case study as an answer to your question. So minor changes giving surprising results are patentable, given that those minor changes have not been hinted anywhere. Okay.
Okay. And sir, can the source code of a software program be patented?
Okay, good question. See, source code is not patentable. Okay, source code, the code itself, is protected under the copyright law. Okay, now copyright, you don't have to mandatorily go and register it. As soon as you create your software, your copyright is also created, and it is created in 110 countries. It is recognized. So copyright is a truly democratic intellectual property right, where as soon as a work product is created, the copyright is also created. I mean, you don't have to have a certificate. You only need to prove that you did it first before anybody else. That's it. That's the evidence you require to prove your copyright on something. Okay. So source code cannot be filed for copyright, but source code is expressing an algorithm. Okay. Source code is expressing an underlying idea. For example, you have a source code for ride hailing application. So ride hailing idea can be patented. Okay. So the underlying algorithm of a source code is patentable, but the source code itself is not patentable. Consider it like a Bollywood film. Okay. All Bollywood films are love stories. Same concept, different expression. So same underlying idea and different expression. Different expressions are protected by copyright. Similarly, Amazon, Flipkart, Snapdeal, okay, Infibeam, these are same ideas. Selling products online, all have different source code, all protected by different copyright. Okay, there may be some great grandfather of e-commerce industry who might have filed a patent on selling products online. That patent may have already expired. But I know for a fact there is a patent that might have recently expired or will expire in near future on the ride-hailing app. It's by an Indian American guy who started a company called Sidecar in US much before Lyft and Uber. He filed a patent in US and got it granted as well. Okay, this patent was bought by General Motors basically to go after Uber, but they didn't go after it. And they rather just have the patent now. That's it. So the ride-hailing idea is already patented, but this patent was not filed anywhere else in the world. It was only filed in US, but there also it was not enforced. So all the ride-hailing apps never infringe this patent. You have to enforce your rights. Okay, if you have a patent, doesn't mean the government will automatically take cognizance somebody is infringing you. No, you have to make an effort, send a notice, start court proceedings, and sue the guy. and to make them and stop them from developing the product any further. Okay, so in the software domain, that's how it works. Source code, you get copyright. You don't need to register it. You have the copyright as soon as you create your software. You will keep on updating it. You no need to go for copyright applications every now and then. But the underlying idea will be protected by the patent. Okay.
Thank you, sir. Yes. Actually, there was, I think, a case in Delhi filed by some of our singers saying that their music was being reproduced. But then I read in an article, they said in the statement that the court case, actually it cost them a lot more than what they got as settlement.
See, that's the, I don't know how they did the how they fought the case. Usually the damages in the patents have also gone up in India. In Mumbai High Court, 5 crore worth damages were awarded to an aggrieved party whose patent was infringed. Okay, and if the singers felt that the damages were lower, they should have gone for a re-evaluation of it. That's the risk you will always have. Sometimes even in US, in Europe, you will always have an opportunity for arbitration, for an out-of-court settlement. Out-of-court settlement is always usually less. Okay, but if the court determines the extent of damage is not that much, then what? Your out-of-court settlement was you were looking for 100 crore settlement from court. Out-of-court settlement was offered to you at 60 crores. You say, no, I want the whole 100 crore. That's where you risk yourself. Court says, okay, there's an infringement, but our accounts, we don't calculate damages at 100 crores. We only calculate it at 10 crores. So that's the risk they took. Okay. So that's where you have to determine if the out-of-court settlement is being offered and you're really worth 100 crore damages, you should press for it. Okay, but the court, in its infinite wisdom, would have given all the justification why the damages are lesser. Okay.
Thank you, sir.
Yeah.
Hello.
Yeah.
Sir, I have already filed for a patent through one registered listing agent. Now, while filing, they confirmed that after doing the patent search, they confirmed that we need not go for provisional, we can go for complete patent. So, is it okay that we just rely on the registered agent?
See, registered patent agent alone can represent you before a patent office. Even a lawyer cannot represent you. Even an LLB lawyer cannot represent you before Indian Patent Office. Okay, a registered Indian patent agent who has cleared the Indian patent agent exam. You can go online and check. If somebody comes to you, I'm an Indian patent agent, go on Indian Patent Office website, put their credentials, and you will see if they are a patent agent or not. Okay, and you can verify the claim. And if somebody is misrepresenting themselves as a patent agent, you can also file a criminal complaint against them. All right, but yes, as far as filing and prosecution before Indian Patent Office is concerned, you have to hire a registered Indian patent agent. Okay. And it's possible that because most Indian patent agents these days, Indian patent exam has relaxed quite a norms because there are very less Indian patent agents right now. So they relaxed norms. Even the fresh graduates out of college are becoming Indian patent agents. So you have to find out an experienced hand who has spent at least 5-7 years in the industry, speaking with patent office, finding out what works, what doesn't work, how to obtain a patent, etc., etc. Okay.
Okay. Once I have already filed patent. Now it is going to be published after 2 months.
Okay.
So, is it advisable to means whether I should check whether a better agent is available so that further proceeding?
Of course, if you're not happy, you can definitely change. The only thing will require is the power of attorney. You don't even have to inform your current agent. You simply have to give a power of attorney to your new agent, and that's it. It's taken care of. It's very simple. There will be some fees, official plus professional, to take over the matter and all, but that's about it. It's not an elaborate process.
So as far as patent search is concerned, means as of now I have to depend fully on the agent, right?
See, as an inventor, you can represent yourself.
Okay.
As an inventor, you can represent yourself. So Indian patent law allows Indian patent agents or the inventors themselves to represent themselves.
Okay, but how
Okay.
patent search means how I know that the particular concept is already patented or not?
That's where the next section is going to be about. I
Okay.
will go to the next section now. All right. I hope no more questions there. So it's also a good
one
way
more
to
question.
move to the next section. Yeah, please.
Sorry, one more question because it's also related to my issue currently. If you file a patent on a product and not file the PCT application for the international patents, now there is a stipulated time, and suppose now the time is also lapsed. And later, if a person in the US, for example, has come up with the same idea, will they be able to get a patent in the US? Because I would think not, because since they when they search the database, they'll find our product. Now,
Yes.
if yes, then does it mean that nobody can now file that patent in any country, including me?
Yes. Yes. Yes.
Okay.
You can file in US
Okay.
even after the deadline has gone. I'll tell you I'll tell you how. If something like that has happened, you can take that route. Now, under the normal laws of patent, okay, you file first in India, then you have 1 year to file in overseas, taking priority from India. Okay.
Yeah.
Now, for example, your 1 year deadline has passed and you never filed in the US. All right.
Yeah.
But now, says 3 months, 4 months down the line, you realize, okay, that there is some interest in the US market. I should file a patent in US as well. Okay. US has what is called as a grace period. Okay, you can file a patent in US within 12 months from publication.
Okay.
So you as in, so India में publication हो रहा है 18 महीने बाद, ठीक है? After 18 months. That's it's a statutory law everywhere in the world. After filing 18 months, it will be published. Okay. Then, so basically, if you are in the 12th or 14th or 16th months of your application, it has not been published. That means you can still file in US. According to US law, you still maintain the novelty. But you will not get the priority date of India. Okay. You will get a fresh date. Okay. But you can still legitimately file patent in US. Your own patent will not be cited against you.
Yeah, but suppose even that time is over, then nobody can get the patent.
Then definitely. See, even the priority, even patent you, and when the patent is not published, can only be filed by you, nobody else.
Okay.
Okay. Okay. Nobody else can file it. Only you can legitimately file it. So grace period is given only to the inventor themselves for against their own publication.
Okay.
Not to a third party. Okay. So for example, now it's been 18 months. Your patent has been published, right? You have another 12 months to file in US. So effectively, in US, you can file patents any time between 1 year to 2.5 years. But the only problem is after 1 year, you will lose the priority of India. You will get a new fresh filing date. That's it. Okay. But it is better than having nothing. You still have a shot at getting a patent. Okay. Okay. So I just gave you a loophole. All right.
But unfortunately, I'm past the loophole. It's 3 years now.
Oh goodness. Okay. All right. All right. So I will move to the next section. Now the question asked was, how do we determine if it's, something is out there already patented or not? That's the next section. It's a good way of moving to the next section of this session. Now, before you conduct a patentability search, okay, on internet, you must familiarize yourself with structure of a patent application. Okay, you must familiarize yourself with structure of a patent application because you're looking for keywords, and patent databases are very much structured, divided in different fields and divided in different, and they capture a lot of data under different heads. So you need to know your patent application structure very well. Okay, once you understand the application structure, you know where to look for your keywords. That's why we will discuss briefly structure of your patent application, of a typical patent application. Okay. Now the title is generally 15 words in India, 20-25 words in some countries. Okay. But in India, it cannot go more than 15 words. Even for a PCT application, it cannot go more than 15 words. Okay. So one of the sections or one of the heads of the patent application is title. Okay. Now title need not be explanatory, that it explains your entire invention in the title. There's no need of doing that. You made a table that is foldable. You can simply just still name your title table. That's it. You want to call it foldable table is a different thing. You can name it foldable table as well. But you don't need to name it like a foldable table with 4 screws and 5 nut bolts with 2 extendable and compressible legs. You don't need to do all this in the title. Okay. So that's the title part. Next section comes field of the invention. Okay. Now the field of the invention is a section used by patent office to classify your document, to classify your patent application in different classes, different categories. So the field of invention, you tell you which field it belongs to. This foldable table, it belongs to the field of furniture or wooden appliances, for example, and more particularly to platforms, to accommodate different articles and all that. So you see how we write the language. I will tell you why patent searching is very different from a scientific paper searching. So this is the field of invention, where you briefly tell which field your invention belongs to. Next section is of background or description of prior art. This section is where you describe your references that you have found during the search. Okay. You need not provide the numbers. It's generally not a good strategy to do that. Okay. You can basically use this section to determine, to say your things. This was the problem, long as it's existing problem, the solutions that have been offered so far. Okay. And these solutions are not good enough. That's it. That's where you stop. So description of the prior art is about you identifying problem with the current solutions or current products that are available in your field. Okay. Then comes summary of the invention. It's again, as it's a self-explanatory. It is summary of your technical summary, a very brief technical description of your invention goes here. Then comes the brief description of drawings. A patent application most likely 99.9% of the time is always accompanied with drawings. Okay, and in that you have a brief description of drawing where you briefly describe the drawing. Is it a top view, bottom view, side view, things like that. Then comes the detailed description. Okay, this is a part where everything about your invention goes into it. All the data, all the surprising results, all the justification of why this composition change was thought of, how it came to you, action mechanisms, everything, every technical scientific information goes into this section, detailed description. Okay. Next comes the claims. This is the legal part of your application. This determines, when you go to court, this is what will determine the extent of damages you can claim. So be very confident with your claims when you do work with your patent agent, because if your claims are narrow, your damages are not going to be very high. Okay, your infringer, if the claims are narrow, your infringer has to work very lazily to work around your claim. That's it. Okay, but if the claims are kept very strong, then you're giving some very hard work to your infringer. So then comes the claims part. So so these are the sections of the patent application: title, field of invention, background, summary, brief description, detailed description, claims. These are the several sections of the patent application. Now, how it is different to search for a patent search is different from a business search or scientific journal search. It's much difficult. Why? The reason is, when you write in a business journal or when you write in a scientific journal or journal of microbiology or journal of mechanical engineering, any like Nature, for example, then you're writing for your peer group. Okay, your addressed audience that you're addressing is at the same technical plane as yours. Okay, if you call something jet engine, they know what is jet engine. If you call it turbojet engine, they know what is turbojet engine. They can make the difference. Okay, if you call it a smartphone, they know what's a smartphone. If you call something DNA, they know what's DNA. If you call something gene, they know something what is gene. So you don't have to explain things to them, basically. Okay. So when you do a search on this internet search, and you use this, you do this search using common keywords like of your industry, you will find all the relevant references rather easily. But that's not how it works in patents. Patents are not written to address a peer group. Okay, patents are written by attorneys addressing the judge. Patents are written for judge. Okay, because ultimate fate of the patent application, if any, is going to be before a judge, and a judge has to be explained why it is not a table. It is a surface that uh, against upon which you can contain, or you can keep article. So you're not calling it table, you're calling it a platform. So what I'm getting at is, while you will look for patents on publications on table, say a foldable table, but you will miss all the patent references where it will be like foldable platform, foldable surface, you know, any other word for table that could be, which, when we are drafting, we will try to extract as. So you will miss out all those keywords, because a patent attorney might have never used the word table itself in the application at all. So you miss that application, even though it has the same mechanism as yours. You are using the term legs. Okay, this guy is using the term member. Okay, a vertical member. You are saying foldable table with legs. I am saying foldable surface with a vertical member. Do you understand the difference between making a normal search in a normal jargon and in a patent jargon? That's why it's difficult. That's why it's a very different kind of searching. Okay. Now I'll take you to a primer on patent searching after now that you have understood the different parts of the application. All right. Now, why do we make searches in patents? Okay, first, definitely the question asked was, how do you find out whether something has been published or not? So this is the one. This is the answer actually. Whether something has whether the wheel has already been, somebody has already invented the stuff I've done or not. Okay. So, but by making patent searches, you can find out who else has been doing the work in your field. Where has it been happening? US has more patents or Europe has more patents? What has been done? What kind of mechanisms are being followed? Gear mechanisms? Is it being driven by gear? Is it being driven by simple push and pull mechanisms, etc.? When was it done? When was the invention done in this? Is it what I'm doing right now? Is it old enough? Once I filed a gun patent, and sadly, because India doesn't allow, not sadly, I don't know what's your position on gun rights are, but because India doesn't allow guns, private guns and all that, so there is no much innovation in the guns. So there's this guy in Rajasthan who did this gun invention about how to, and this gun model of 1950s, and the invention was done in US in 1950s itself. What he was doing in 2000s, and he had no idea. Okay, but he figured it out, something similar to what was done in 1950s. So it happens. So you can see when was it done. How was it done? Sometimes there may be a foldable table that you have developed, and somebody else also has developed a foldable table, but their way of folding is very different, and yours is very different. You will still have a patent. Okay. Now, apart from, another thing is, if you are in the field of life sciences, especially, or chemicals or oil and gas, you will note that most of the research is recalled. Redaction is a big problem in research papers. Okay, while patent documents are said to have higher reproducibility, they are more, you can say, they are more dependable. If you want to have more biotechnology rich information, patents are a good document. If you want a more pharmaceutical oriented rich information, these are the documents you're looking. So patents are more dependable document. You also do search to know whether your invention is new or not. And you also do search sometimes to improve on the previous one. Okay. Now, where to search? Where do you make these searches? So this is the answer. This is where you make the searches. Many public and paid databases are available. Okay. Paid databases are like Orbit, Thomson Innovation, Rally Cura. These you have to pay. For example, Adastra IP, our company, we subscribe to Orbit. It's a $10,000 one login ID. $15,000, right? We took the biological sequencing module as well. So that's how expensive it is. Then there are public databases as well. You don't really have to have a $10,000 subscription. We take it because we are professionals, but you can use public databases which are as good as paid databases. Okay, but then you have to search for, because we are looking for a global searches, right? We are trying to do global search. So you have to make searches in all the important countries: US, Europe, Japan, India, Malaysia, Singapore, UK, Canada, Australia, all the important countries. And these databases are freely available made available by all the countries. Okay, you can go to USPTO website. This is the database, patft.uspto.gov. Then there is a eSpaceNet, is European Patent Office database. European Patent Office database will give you search results from 110 countries. Okay, but it will not give you more than 200 or 500 results. Then there's Google Patents, which has increased its jurisdiction reach to 40 countries now. Then there's Patent Scope. Then there's Free Patents Online. So you can make your patent searches in these databases. Okay, instead of simply going to internet and making searches, go to dedicated databases and make searches. All right. Now we'll go to how to make this search. Now, this subject can be broached in two very different manner. One, by the students, they might want to learn about it because maybe they are preparing for some career opportunities in IP and they want to know about searches so that they can, have a go at it when there's an interview. And for startups, you are looking at this particular section to do your own searches because you are an entrepreneur, you're an inventor. You will be thinking of a lot of ideas, right? It's a weekend and you thought of a new idea. You thought, why not just also do this? But I'm a patent attorney and I'm telling you this. You don't have to come with each idea to a patent attorney. You can do a preliminary check at your end, at your own level. Okay, so hopefully this will give you a good enough exposure to do a very healthy preliminary check whether this idea has been done or novel or not, something like this. Okay. Now, how we approach a subject when we do a search is we break down an inquiry into several features or concepts. Concept A, concept B, or concept C. Like you have, say I have a toothbrush with an activating chemical to activate a cleaning agent in toothpaste. Okay, so whenever the toothbrush rubs against the teeth, this activating chemical activates a cleaning agent. Otherwise, it's in the sleeping mode. Okay, so now there are three concepts: a toothbrush, and a toothbrush must have an activating element. And then this activating element must have an ability to activate some ingredient in a toothpaste. Okay, so the invention is not in the toothpaste. Okay, invention is in the toothbrush, which has the activating element. So some chemical has been attached to the bristles of the brush. Okay, so I have broken the inquiry into these three concepts. Now, next thing you have to do is start coming up with the first list of keywords. It's an iterative process. You will, if you're doing a good preliminary check, you should spend at least 3 to 4 hours conducting a good search. Okay. Out of that 3 to 4 hours, 1 hour could be on coming up with all the keywords possibly that you can think of. Use your imagination and technical expertise in coming up with the keyword. For example, a mobile phone may be called as hand phone, wireless phone, cordless phone, smartphone, or just simply phone in many applications. Okay. And within this also, hand phone can have a hyphen, like in England. Smartphone can have a hyphen, or it can be one word. So you have to make sure of the English language because it's tricky. So you have to account for all the different variations of a spelling as well. Okay. Then you look for these keywords in different sections of the application. Okay, title in abstract and description or claims. Mostly you look for your keywords in title, abstract or claims. Okay, if you want to go for very detailed oriented search, then don't look in claims, then look in description alone. Okay, you combine your keywords with Boolean operators that you might already know. You do Google searches. If you want for example, I want to have toothbrush and activating chemical coming in the same document. So when I determine novelty, I want these three concepts to be combined together, and then I make a search. So I have to come up with a keyword for concept A. So concept A is toothbrush. So I can have to come up with all sort of keywords for this concept. Okay, and then I have to combine this concept with concept B's keywords, and then with concept C. So first search I will do is combining all the concepts keywords through AND operator and see if there is a patent application out there. No, then I will combine two. Toothbrush having an activating element. If nothing turns up even then your invention is novel. Okay. Now I will just do an exercise. What kind of keywords can you think for a toothbrush? Anybody can answer. Different keywords for a word toothbrush.
Bristles.
Come again?
Bristles.
Bristles are on the toothbrush. But it's but for concept, at the concept level, it's good enough. So we'll accept bristles.
Tooth cleaning device.
Come again?
Tooth cleaning device.
Tooth cleaning device. Yeah. Anything else?
Just a brush.
Tooth care.
Just a brush is. See, now the brush, if you use just a brush, then you're also accommodating vacuum cleaner brush, cleaning brushes, all sort of brushes. So you are expanded the scope of your search.
Or tooth dash brush. Another one.
Can be, but let's consider it as a one keyword only.
A teeth cleaner.
Teeth cleaner, yes. Most important word that could be used is oral implement. Okay, oral cavity cleaning device. I am telling you, as a patent attorney, we'll use something like this. Okay, so you
smile enhancer.
Yeah, we won't get that creative. We'll definitely get boringly creative, like oral implement, oral cavity cleaning device, etc., etc. Okay, so then this is your first set of keywords that you come up with. You go ahead, make the searches again. Okay, once you make the searches, you will come up with different patents. You will find more keywords from that search, those results. Include them in your iterative list. So you have to iterate a lot of time before you can finalize, okay, I have covered all the potential keywords. Okay, so that's how the search is done. So you have to come up with keywords after keywords, list after list, and keep on conducting searches and finding references, reading them, shortlisting them, and then analyzing them later on. Okay. Now, what informations can you use to make patent searches? Okay, you can make inventor-based search in all the databases. In every database, you can make this search. If you know that this guy was already working in the US in this particular section, let me see if he has already invented something in 3D printing, for example. So you look for this company or this inventor, and you go out, find out patents filed by this university or this inventor or this company. And you find out, oh, they have not filed a patent covering this aspect. So you can go ahead and file it. Okay, that's another way of quickly arriving at a conclusion. You can also do a number-based search. If you already know the application number or patent number, you can simply put the number and you can get the search done. Okay. Now this is crucial. This is more for students, but if startups can also, master it or not master it, can also get a hang of it. It will help them quite a bit. Now that I told you all the patent applications in the world, I hope you guys can see the screen. Can you guys see the screen?
Yes, sir.
Yeah. See, I told you, field of invention is used to classify the patents. You remember that? So all the patents of the world are classified according to this coding. If your patent falls in human necessities, it will be coded under A, operations under B, chemistry, metallurgy under C, textiles, paper under D, construction related under E, engineering, lighting, heating, weapons under F, physics under G, electricity under H. Okay, so your patents will be
that one. We
which
can't
one?
see that A, B, C, D. We can see
Oh,
some other the slide only.
Wait.
You only see your slide, DS.
Let me
the using
reshare.
patent.
Let me reshare. Can you see now?
Not yet. Yes.
Yeah. So this is the classification of patents. So all patents are classified in any of these categories, and don't be outside misled by the innocence of this database. See this. Within human necessities, you have agriculture, foodstuff, personal or domestic articles. So a toothbrush related patent will come somewhere under this. Okay, brushware, A46, brushes, A46B. Under brushes is brush bodies and bristles molded as a unit. Brush bodies, bristle carriers arranged in the brush body. So there has been so much invention in the brush. There is dedicated categories for brush itself, like accessories for brushes, devices for holding brushes. Okay, so you will see when you make a keyword-based search, okay, and you come across some relevant patents, you will see a code will be one code will be given in that document somewhere in the patent. I'll show you where. For example, can you see the screen? Hello, can you see the screen?
Yes.
So this is a toothbrush patent, as you can see. It was granted as early as 2000, as late as 2015. So there's no, it's not like toothbrush has been invented and done with. Humanity is still trying to improve it. Okay, you never know which one of these goes mainstream. Now I'll show you the. Now you've found out the patent document. This is a PDF, right? And now you see, I told you this is the classification. This A46B. So the goal is that you, through using keywords, you find relevant patents. From those relevant patents, you find the classes. A46B 9/045. Let me see what this class pertains to. A46B 9/05. A46B 9 here. 045. I think it's a older classification we are referring to right now. This is CPC. Okay, let me go with the IPC. There are many classifications, but this is the one widely used now, cooperative patent classification. It is used by Indian Patent Office database as well. So if you can zero in your class of your invention, it will make it easy for you. So A46 D 945. This is one. See, so A46B 945 relates to bristles in the brush body meant for cleaning tooth surface. They're not calling it teeth, tooth surfaces simultaneously. Okay. Or so this class A46B pertains to toothbrush. So you can file all without using keywords. You can find all patents related to toothbrush under A46B if you put that class in the database. That's it. So that's what we are getting at. Okay. I hope it was not confusing, because it will really help you a great deal when you make the searches. So idea, as I said, is to use keywords, iterate it of many times, arrive at relevant patents, see relevant patents, find out relevant classes, put those classes and mix them up with keywords, and then get more dedicated results. So you will have more dedicated results. You will have more dedicated, more relevant references. Your noise will be cancelled out. Your signal will be clear. Okay. So that's why we use patent classification system. It's used by patent attorneys, founders, professors. If you get hang of it, it will be very good. All right. Now, how to apply that bullet rule? You can search for keywords in description, in abstract, in claims, in title. You can search by class. You can search by inventor's name. I have taken screenshots of some examples here to show how it works. Okay. Now, this is USPTO database. Okay. USPTO database. I searched for, can you see the slides clearly? Or should I zoom in?
We can see it.
Yeah. Is it clear now? I think it should be more clear. You can see in the USPTO database, I search for paper and clip. I say all fields. What it means is, at USPTO database, I'm saying look for paper in all the fields, clip in all the fields. I mean across the application, anywhere. So find me all the documents where the word paper and clip appear anywhere in the document. Together, not together as in same document. So there are 24,000 patents. Okay, and you can see all the irrelevant results. I'm looking for paper clip patents, and the first result it shows is near field communication device as an initiator to high data rate communication. Okay, so you do not want to make this kind of searches. I'm looking for paper clip patents, and this is showing me NFC devices. It's nowhere near the paper clip. All right, so that's why you want to narrow your field of search. You don't want to search in the entire application text. Okay. Now I will use the same search, same terms, paper and clip, in abstract. So I'm saying find all the patents that has word paper and as well as clip in their abstract. So it reduces my patent set from 24,000 patents to only 297 patents, and as you will see, they are more relevant. Okay. Similarly, I will look for in claims. It will show me 750. Okay. So in different fields, different combination, I'm getting different number of hits, and it's, as you will know, why is it so? Okay. So you have to do this iterative process again and again to zero in your exact document or exact publication that you think will be dangerous for your invention, for getting a patent. Okay. Then filing any paperclip patents, you can find out. Okay, inventor name, inventor city, CPC classification, you can find all these are the criteria for you to search. Now, another exercise for you guys. We are looking for patents on paperclip. What could be different keywords for word paper? Come on. You are looking for paperclip patents. What could be different different keywords for patents? Hello.
Organic writing material.
Organic writing material. Okay. Something more. Something like 1 or 2 words.
Writing surface.
Writing surface. See, now writing surface, you look at it, we are looking now, also give a context to your keyword. You're looking for paperclip patents. Okay. So writing surface can even be a board or a table, anything. So it's very less likely an attorney using the term writing surface when he's describing a paperclip invention. Okay. So give me more contextual keyword. Come on, guys. Paper. Different words for paper. Come on. Page, yes. Sheets. Right? And page, sheet. What else?
So one should use a thesaurus, I think.
Thesaurus is a collection. It is it's kind of a book. But I'm looking for paper. Generic paper.
Book.
Page, sheet. In one of the patents, I also saw the term that was used was foolscap. If you have read Sherlock Holmes books, Arthur Conan Doyle does not call it page; it calls it foolscap. So many patents in US older patents will use the term foolscap, like foolscap. Stacks. What else? Rim.
A4.
A4 नहीं. Rim होती है ना, sheets की rim होती है. Rim can be used. What else? See,
Thin
you see.
printable sheets.
Thin printable sheets. That's quite a big keyword, but I give you that. Imaginative. So that's why you need to get imaginative with your keywords. Okay.
Sir, you're not sharing your screen, I think.
I'm not sharing it. Is it visible now?
Currently, we can see the slide, the presentation slide.
I'm only on the slide only.
Yeah.
I will run a live internet search. I will run the search shortly. Can you see this? Other criteria for searching sheet. That's it, right?
We see finding your way.
Oh. Can you see now? Okay. So what could be the keywords for clip? So you're done for paper. What could be keywords for clip?
Stapler, pin.
Pin. Okay. What else?
Clamp.
Clamp. Okay. What else?
Paper holder.
Holder. Yes. What else?
Binder.
Keep coming. Binder. Yes.
Crocodile clips.
Just clip. See, these are the words like pin, clamp. You will have mechanism, clamping, assembly, retainer, tying, hold, fastening. Fastening means, for example, holding means securing, locking, seal, bolting, fixing, joining, retention. So I'm given the roots of many keywords that can be there for word paperclip. Okay, so that's how imaginative you need to get when you do a patent search. For example, you are making searches on paperclip or paper securing device, while the patent attorney used a paper retention device. That's it. You have completely left a patent that could have been, very critical to your own decision, whether to file a patent or not. Okay. And I will show you how paperclip patents are being granted. This is one of the first paperclip patent that was granted in 1866. As you can see, it's very simple. You will still find its use in government schools in India somewhere. Okay. Then on the right is the paperclip patent. On the right is the paperclip patent granted in 1901. This is the standard paperclip patents. Paperclip you will see now. Okay. This was one granted in 1897. As you can see, this is also quite prominent. But this is the one which is very prominent. You can realize it by looking at the drawings. It's very prominent. It's the paperclip. This was allowed in 1901, this patent. Okay. But did the people stop inventing paperclip? No. This is a patent granted in 2016 on paperclip. Okay. So what we are getting at is, you don't need to invent a rocket to get patents. If you have a product and it has a considerable improvement within its own field, you will have a patent on it. Most inventions are on incremental inventions, incremental improvements. Okay, that's where most of the business is also happening. No other businesses. Most businesses are actually selling a better version of an already existing product. That's how they enter a new business. Okay, so why not have a patent on it? Well, because the old player who is already selling the version of product will definitely want to scale up and capture that market as well. Okay, so you don't need to look at your inventions from that it need to be super duper, very heavy, very extensive. No, simple objects, simple invention, solving a very complex technical problem can very well be patented as well. Okay, I think I will leave it at that. I will also now show you how do we make search. Some databases, I'll just familiarize you with some databases so that becomes easy for you guys. Some databases so that it's sure. Can you see the Google Chrome? This is IP India website. I'm opening now. Okay, this is Indian Patent Office website, ipindia.nic.in. Is it visible?
Yes.
Yes, sir.
Yes.
Yes.
And that's where public search, you go to public search, and that's public search for patents, for trademarks, for designs. We are going to patents. Yes. Okay. Now tell me what you want me to search here. You can see there are different criteria. You can search your keyword in title, in abstract, in complete specification as in description. You can, if you know the application number, you can search by that. You can search by patent number. You can search by applicant name. You can search by filing office. It was filed in Delhi or Kolkata, like that. You can search by PCT application number, like this. So these are the only criteria available at the Indian Patent Office website. So do you want to has anybody among you filed a patent? We can search it right away. Just give me the keywords. Let's see if we can find that patent by using keywords.
Hello, referral marketing.
Come again?
Referral marketing.
So you have filed a patent on it, referral. So I'm select logical operator and I'm looking for abstract again, marketing. Indian Patent Office database, you must see the version help here, how they combine the keyword. Okay, like computer. If you use the word as computer star, so it will find all the patents where the sentence starts with the word computer. Okay, if I say that radius, so it will find phrases or sentences that have radius in any position. Solar star panel means find phrases or sentences that start with solar and end with panel. Okay, so these are the different commands that you can familiarize yourself with. Okay, So now we go to referral marketing. Is it your own patent or we are just searching patents, you're saying?
Our own concept.
Your own concept. You have filed a patent for it?
Yes.
Let me see, just let's use simple word referral marketing first. That's what I do. I first search I make is of the words used by the inventor themselves. Okay. Some problem with the captcha. Okay. So there are 4 patents which mention referral marketing in the abstract. So is any of these your patents? Multi-level network-based incentive reward system for retail commodities. This looks like a referral marketing. Then this is for systems and methods for network referral marketing transactions. Is that your patent?
Yes. First one and second
Are your
one.
patents, right? So referral is incentive. So if we couldn't have find anything on say referral, we would have used word incentive. Okay, incentive or reward or award. Okay, performance. Okay, so all the related, you don't be exact synonyms. It can be in the ballpark. Okay, that's how you will find out the relevant patents. Okay, so hope it's clear now. So if you want to say, I want to find all the patents that Facebook has filed in India, for example, you're working in 3D virtual reality and Facebook has done something. Let's see how many patents has Facebook filed in India. So applicant name, Facebook. That's it. I'll just put Facebook, HHX5. Then I make a search. So 200 patent applications are pending with Facebook as the applicant. If I click here, proximity-based trust, okay, and the applicant is Facebook Incorporated. This is the application. You can find the entire history of it, application status. Indian Patent Office database, like other advanced countries database, makes available all the stuff online. Okay, so you can see all the documents that have been filed. What was filed? A complete specification you can see here. Okay, so if you're working on something like this, on proximity trust and all that, so you can read their patent, see what they're doing differently and how you are doing it differently. This is their document. Okay, yeah, somebody was asking something. Hello. So guys, I hope it's clear now, right?
One question here.
Yeah.
Yeah. So when we are filing our own patent, then should one be shady about the name so that the others can't file the patent so that you can sue them later?
See, the thing is, a patent attorney, a professional, will always find your patent. We will use keywords, and there's no point in doing it. See, you must understand that it is very important to give a warning before you approach a court. Okay, if you purposefully make your patent like undiscoverable by using very generic and vague keywords and definitions, the infringer can rightfully ask court to invalidate your patent. Okay,
yeah.
Or under other grounds, not under the patent law, but under the grounds of that you were not properly informed you didn't properly inform the public of your rights. That will be the ground. That's why it's important for you to mention patent pending on your articles.
Yeah.
When the patent is granted, you have to mention patented. If you're registering a design, you have to mention the design registration number on your product. Okay. If you do not do that, you are already on a sticky wicket as far as filing a case against an infringer is concerned. Okay. If you do not put R on top of your trademark, you're not giving public a good enough warning that this is a registered trademark. Okay. So that gives a leeway to other party. Okay. That gives a leeway to other party to get back at you. That's it. And you don't want that. You're filing patent, be upfront about it. Okay. File patent, say patent pending, patented. Because filing vague patent and all that will also be detrimental to you. You may not get a patent as well.
Yeah.
Okay.
Well, that makes sense. Yeah.
Yeah. So that was Indian Patent Office database. Then you can go to Google Patents. Very smart it is becoming because of Google's own algorithms. So you can still make searches here. Tell me something you want me to search. Let's see what we can come up with.
Automatic door.
Automatic door. So you can see it's all Google Patents starts providing the references themselves, right? But you can still do this. Automatic or automated or self-operated, okay, or sensor or proximity, okay, and door or door नहीं हो सकता, window भी हो सकता है. और क्या हो सकता है door की जगह? What other things could it be? Door के लिए और क्या synonyms हो सकते हैं?
Your cover.
Closer.
Gate, entry, hatch.
Hello, there is no sound.
Yeah, we can't hear anything.
There is no audio.
Yeah, it has gone.
Hello. Sorry.
Uh-huh.
Okay, it got muted. I don't know why. Okay, what I was saying is you can narrow down your field of inquiry as you go further. So, for example, you didn't want dishwasher related patents. So I said, why not go with room? Okay, we use the keywords room, bedroom, premises, space. Then we found out all these patents here, 3.9 million patents. Okay, all most related to operation room or medical room. Then you say, okay, but now you want to be more specific. You say, I want a room automated door that closes when a wind speed is high. Okay, then I say, okay, wind. That's it. I search with it. Then I come across patents, 67,000 patents. Now you will see all patents relate to something which work on wind or work through wind. Okay. automatic switch window systems, automatic window opening and closing device. So if you wind speed sensor, as you can see, so this patent could be relevant to what you are making in automated door. So it will sense the speed of the wind and it will close itself. Okay, see, wind speed sensor. Okay, so you can continue to narrow down your field of inquiry. Start a concept. Your concept was automated door. We found out automated door. Okay, you say, oh, so many patents. Then you say, my automated door works not with dishwasher or washing machines or refrigerator. My automated door is for homes or houses. We say, okay, go ahead, let's do rooms, bedrooms, closures, space, and not only door, we will also use terms like window. Okay, then you come across many more patents. Then you say, no, I want to make this door automated on certain input, say wind, or it can be, it's evening, the door should close itself, right? So you can change your parameters. So now you have broken down your door, automated door, in different concepts. Automated door for rooms, automated door for rooms that are automated by the wind speed. Okay, so that's how you arrive at the correct reference. Now, for example, I go back, let me find out the US patent or European patent on it. Let's see if there is a class that is relevant to US patent. देखो सारे Chinese documents हैं. Unfortunately, you will find a lot of Chinese patents. They have flooded. Now this is a control apparatus. See, they are also using the term apparatus. Okay, control apparatus, door or gate drive apparatus, method for moving a door and or a gate. Okay, so if I open this, I go to download PDF. Okay, and see, I use all the correct keywords, everything. So I find the international classification. So under this category E05F 1571, all similar patents may be located. Now I can go back, do some backwards calculation, CPC patent classification. I go here. Hello, guys. Lost the power here. Can you hear me? Hello.
Yes, sir, speak.
Hello.
Yes.
There was a power cut just now, so I'm connected via my mobile internet. Okay, now if I do a classification search, see, we were looking for automated doors. So we did some searches. You find a relevant patent which you feel like it's opening door on every other sensing condition. You know, having a sensor device detecting at least one atmospheric condition, can be wind, rain, very broad patent, and it has been classified under a certain category. So that category was this. Download this. So this category is this one.
Your voice is not clear, sir. Your voice is cracking, sir.
Now I'm trying to find out to get it right. Hello.
Yes, sir, speak.
Am I audible?
Yes.
Yeah. So you can see under E05, all patents related to locks, keys, window, are listed. Okay, then within E05 there is a F category. E05 F, devices for moving wings into open or closed position. And then we are looking for 15, power operated mechanism for wings. So all your automated patents can be found by using this category.
Sir,
Okay.
are all these patents in English only, or like could it be that there are some in some different language and it has not been translated yet?
Good question. See, Google Patents will automatically translate the patents of other authorities to English. So, for example, you see the this patent, you saw the many Chinese patents, right? These are originally filed in Chinese language. Okay, this one, see, this is the Chinese patent CN2044, but Google Translate will translate it for you in English. So it will be made available to you in English language in as good translation as possible. Okay. Hello.
Yes, sir.
Yeah. All right. So this was on Google Patents, how you make search. Then there's a database eSpaceNet, which is European Patent Office database. So this is eSpaceNet. You go on patent search. Okay. And same mechanism. I prefer classic eSpaceNet. So I'm going to classic. Then you go to advanced search. This is advanced search. That's it. So here's title. If you want to search for any keyword in your title, you put it here. Automated door, for example, just same mechanisms. The principles are same, automated and door. And you can also club with several keywords or window like this. Okay. And then you can search by applicant name, inventor name, and you can press search here. And then it will show you results like this. Okay. This is how you make search on European Patent Office database. All right. European Patent Office database covers 110 countries. So you will get results from 110 countries. All right. Now,
could it be the case that we might miss out on some patents because of language translation issues? Or
it is possible. It is possible. It is possible. That's why you have, see, for example, if I say automatic door, okay, an automatic door need not be powered by electricity. Automated door needs to be powered with electricity. Okay, you must understand the nuances as well. So it's possible in the translation that nuance is lost. An automatic door is something, if I remove a hinge, if I remove a restraining mechanism, it will close automatically like a spring. That is also automatic, right? But we are talking here about automated, right? So make sure so that's why we go with as many keywords expansions as possible, so that the words are not lost in the translation. Okay.
And there's no common database, or one has to go through all these different databases, like for 5, 6 that you've shown.
You can use European Patent Office database. It covers 110 countries. So you only, but its disadvantage is you can only search for your keyword in title or abstract. You cannot search for it in the detailed description. You can see worldwide collection of published applications from 100+ countries. Okay. So but you can only search for those keywords in title or abstract. That's why the inquiry automated door or window gave you only 367 results. Is it possible that are only 353 patents on automated door? No, there must be around easily 10,000, 15,000 patents. Okay, that's why you need to go through different databases in the interest of thoroughness. Okay. Then there is a USPTO. Yeah, please.
Yeah, this a small question related to that only. But suppose we go through a database that is covering now a couple of these databases will overlap and cover the same countries. So if we take any one of these database, suppose I'm only interested in what's happening in Europe, most of the European countries and US, and I'm not interested in others. So can I confidently just take one of these databases which cover both these areas? Will they have the same without missing out anything?
Yes. think in that another is covered. You can use any one of them. For example, this is a patent lens. Hello. Yeah. So this is patent lens database that is available that you can see. So here you can search in these jurisdictions. So these jurisdictions will be covered for you: China, Japan, United States, Germany, European patents, Korea, WIPO, United Kingdom, France, and Canada. And these are the technology developers. Anyway, okay. Hello. 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 Hello.
Yes, sir. Speak. Continue.
Okay. Okay. So this was about the different databases. To conclude, this is how you will determine the patentability as potential of your product. You will have to make some searches here and there. Like you do market research, you go for different databases. Okay. So for patents also, you need to go with different databases, but you need to be very creative because the information is much more structured than a market research. So because information is structured, you need to know the structures of the database, which I've already explained that it depends on the field of the application. And you need to be imaginative with your keywords. Okay. Please ask questions now.
Good afternoon, sir. Am I audible?
Yeah, you're audible, yes.
Sir, myself, Parth Kachari. I am working with Kyneco Limited over here in Goa, and I'm heading R&D over here.
Okay.
So we have done some product research, and we have made some products in Kyneco.
Okay.
And there were done
Kyneco, as in which company?
Kyneco Limited.
Kyneco, K-N-I-C-Y-N-E-C-O.
No, it's K-I-N-E-C-O.
Okay. Railway equipment supplier. Okay. Yeah.
Right.
Please tell me.
So we are now planning to do patent for that products, whatever we have made, but we don't know how to file it. So my question is whether any person or any company can file patent by their own, or it is
Hello. Hello.
Yes, am I audible?
Yeah, you're audible. Okay, you were asking whether any company can file the patents by themselves, or you need to get a patent attorney, right?
Right, sir.
See, if you're as an applicant, you can represent yourself. Okay, if you can draft good patent applications, you know what claims are, etc., etc. You are definitely very much in your rights to file your own patent applications and represent yourselves before Indian Patent Office. Okay. So you have a right to represent yourself. That nobody takes that away from you. But you must understand, have you written patents before? Have you guys drafted patents before?
Yes, sir.
Have you drafted patents before?
No, sir. Not, sir.
No. Yeah. So in that case, I will recommend that you employ professional services, because you see the patents require you to disclose everything that is known to you about your invention. Okay. If you disclose it all and do not claim it nicely, then what you have done is a great disservice to your own research. You have disclosed everything, and in return, you didn't get any good patent as well. So it's better to even rather not publish it, or rather not file a patent at all on it. Okay? Because you will, when you file a patent, you are necessarily disclosing much more technical information to your competitors as well. They can also go online and check. Okay? But if you're not claiming it back properly, then that will backfire. Okay. Am I, hello, Mr. Parth? Hello. Hey, am I audible?
Yes,
Sir,
you're
you're
audible.
audible.
Yes.
I think
Okay, so Mr.
like
Parth,
Yes, sir,
yeah,
I lost in between. Just I
okay,
can.
okay. What I was saying was, if you do not know if you have not drafted applications before, okay, you will be doing a great disservice to your own inventions as well, because patent law requires you to disclose substantial technical information about your invention, okay, and if you do not claim it properly, you will be disclosing it all with no return. And I have seen that happening with many MSMEs. They file their own patents, and and especially because they have not filed it before, they haven't had any experience as well. Okay, and it usually backfires. They disclose things, and they are not able to even legally obtain the patent. So even in that situation, it's even better to not file patents. Keep it as it is instead of disclosing everything and not getting anything in return. Okay.
Right, sir.
So I would recommend that you use services of a patent professional. If you how many patents are, I mean, depends on if you have not done it before. That's what my main concern is, because MSMEs do jeopardize their patents when they do it themselves.
Fine, sir.
Yeah.
So in that case, are you helping for this kind of patent filing, sir?
Yeah, we do all the patent filings, patent, trademarks, all sort of intellectual property rights.
So can we talk subsequently after this meeting, sir?
Sure, no problem. We can.
And from where I can get the contact details, sir?
Let me put it. Can I put it on the chat here?
You can share your contact details and today's PowerPoint.
Yeah.
After the.
You please share. Yeah. I think Sudeep will share. Any other questions on the matter at hand that we are discussing?
Okay, sir. Thank you, sir. Thank you, sir.
Yeah.
Hello?
Yes, please. I'm listening.
So actually, I have two questions. First question is related to patents only. Once you file a patent, what I got from your presentation is that everything, the whole responsibility of filing patents or confirming them lies with the inventor. Okay, so suppose you file a patent. Usually, the case is that once the product goes mainstream, then you have the second day or the third day somebody comes and says that it is infringement upon his rights. In that case, what is the resolution mechanism? And secondly, sir, what are the royalty fees that could be associated with a patent?
Good question. See, when you have filed a patent, you obtained a patent, there's a party infringing on your patent. What are the ways to get out of it? Right? So, the first thing you must do is alert your infringer that you have a patent which is granted. Unless your patent is granted, you cannot take any legal action against your infringer. Okay, so wait for your patent to be granted first of all, and practically I would say wait for 1 year after your patent is granted until you take an action against your infringer. Okay, because Indian patent law has a post-grant procedure. Okay, so if your patent has been granted and you just after the grant you go after your infringer, you make his job easy to challenge your patent. Okay. So don't make it easy. You have to wait for 1 year, let the 1 year go so that he cannot challenge you at the patent office. Make the infringer work hard for it. He should go to court to challenge your patent. And going to court is expensive. The infringer will think twice before doing anything like that. While challenging the same granted patent before patent office is easy, cheaper. Okay. So wait for 1 year. And then after that you send a notice that this patent application has been granted. Immediately you're requested to stop the production and marketing or export of this particular product. Okay, and they are given 15 days notice or 20 days notice or 1 month's notice to reply to this and confirm that whether you are going to do this or not. Okay, most likely the infringer will go back, discuss with their lawyers. If there's an infringer, the lawyer is very likely to advise to stop the production altogether, or find a way out that you can still sell the product, or maybe edit the product, change the features of the product and sell it in the market. So basically your patent is making them work and think. It's already fulfilling the purpose. If they do not stop, Another offer you can put on table is, okay, if we don't want to have a lengthy code battle, why don't you license this technology from us and keep selling under your brand name, and we are also selling. Okay, I would rather have you discuss with infringers on the same ground, that you license the technology amicably, and the royalty rates are determined by the market. Okay, you have to see in your industry, is it high volume, low value industry, or is it low volume, high value industry? Okay, how it works. Depending on that, you can put your own royalty rates there. Royalty rates, there's no hard and fast rule. You can say, I want 15% of the profits, or 15% on the revenue, 5% on the revenue, 15% of the profit, any which way. Okay. Mostly, or you can decide royalty on per piece basis. You sell one piece, I get 5 rupees. Okay. If the piece is selling for 1 lakh, you say, okay, you sell one piece, I get 5,000 rupees. So you sell 100 pieces, I get 5,000 to 150 lakhs. Okay. So, sorry, 5 lakhs. So I get 5 lakh rupees. If you sell 1,000 pieces, I get 50 lakh rupees as royalty. So you can tie up your royalty with any parameter, any variable, depending on your own business and everything, which makes your accounting easy. For example, you don't want to calculate revenues and all that. You say, okay, tell me how many units you sold. Okay, if it's a like a FMCG product, like a toothpaste, you say, you tell me how many toothpaste have you sold. I'll take 1 rupee from every toothpaste. He says, I've sold 2 crore toothpaste in this year. So give me 2 crore. That's the royalty. That's it. Done. Okay. So you can determine your royalties, the parameters that you tie your royalties to very differently, very creatively. It's all right. If that also gets derailed, infringer is still not listening, you go to court. And in India, courts are very likely, if you have a granted patent, if you've gone through all the headaches and pains of a bureaucracy, they will give you ex parte injunction against the competitor. The competitor against a commissioner ko order kar diya jayega to seize and seal all the goods until the trial is pending. That's it. So you will get, in the end, you will sail through. Okay.
Hello.
Yes, sir.
Hello.
Sir, actually, my question was the other way around. In this case, you have already got the patent, and you are about to go mainstream with your product, but somebody comes along and says that he has already filed this patent, say 10 years or 20 years back.
Then you negotiate. Then you see whether you really infringe them or not. That's why there was recently questioned by Mr. Kaineko, right? If the application has been filed by MSME in India, I'm telling you, very likely they did not file patent on what they were seeking for. I have done so many successful negotiations simply on that basis. Okay, what they usually mean is, for example, you're selling a cup with a handle, okay, but they filed a patent only on the cup. They never filed a patent on cup with a handle. So even though they are also selling cup with a handle, okay, so you copied their product, you're selling it, but they never actually filed patent on the actual product that they're selling. So you never infringe a product. You're never copying, you're never infringing a product. Nobody can come and tell you, okay, hey, even though I filed patent on the cup, but you're infringing my product which has a handle. They cannot say that. You have to infringe the patent. Okay, so that happens with MSME. So you need to see whether their patent actually protects what they are selling or not. If not, you're off the hook. You have to do the analysis. That's the strategy you can build. We do that successfully against many MSMEs where the patent was filed 5-7 years ago, and mostly by themselves. That's the risk. That's why I was getting at, because it's our own experience where we have defeated MSME patents very easily by simply saying that, okay, you filed patent on your patent is on ABC, but you're selling ABCD, and my client is also selling ABCD. So you are suing him for copying your product. You cannot sue them for that. You can only sue them for copying your patent. So your product is different and your patent is different. That is a fatal mistake you can make in IP. So you must protect your product. Okay. So if you have received such a notice, ask them to send you claims, send you a patent application. Ask them to give you granted claims. What was granted? Take your product and map it against the claims and see if all the features are actually there or not. Do not go by their product. They will sell you products copy, products features, it doesn't matter. Tell them to give you patent application. tell them to give you the patent that was granted and the claims that were granted. You will always check infringement against a granted claim. That's it. Okay. So they can't browbeat you on the basis of product features.
Thank you, sir.
Hello.
Yeah. Yes, please.
Hello. Hello.
Listening. Yeah.
Hello.
Hello. Yeah, I'm listening. Hello.
Okay. See, I have already filed a patent and publication is pending after 2 months. Now, actually, we wanted to start, means it's an app-based system that we have developed. So now we are planning to launch the app before patent is granted. Is there any risk?
There is no risk. Okay, on your patent application, where if your mobile app you're launching, you can make a legal disclaimer of sorts. Okay, where you can say, okay, this copyright in the appearance and user interface belongs to you, and there's a patent pending. You know, come up with a sort of IP disclaimer. Make the public aware, users aware of your IP rights. That's it. Do that, and you're good to go. Okay.
Okay.
Any other questions? So I hope, guys, as a startup founders and the student, I was just concluding it that MSMEs, especially industries, they spend quite a bit of money on R&D, and then so patents must be considered, or even startups. You know, you pull in all your savings and of several years and try to build something up. So patents must be considered like a mediclaim, like an insurance. Okay, that's how it should work. It should not become center of your company. It should simply be working at the periphery, protecting your assets the way it should be. You shouldn't spend more than what's needed on patents. Don't go crazy filing patents on every damn thing. But also do not shortchange yourself by not filing if something is absolutely essential and absolutely patentable and is critical to your business. All right. And any other questions, I'll be more than happy to answer now. Or you can simply send inquiries to Sudeep, and then I can just reply over the call as well.
Yes.
Over the email as well.
So what is the procedure to become an IPR agent?
Procedure to become an IPR agent. Okay. See, to be an IPR agent, you first and foremost must possess a technical or science degree. Okay. And then there is a patent agent examination that you have to undergo. There are 2 exams. One is on Patent Act, and then one exam is on patent drafting. So you have to take that exam, and that exam was supposed to happen in June. Because of lockdown, it has been postponed to indefinite date. The date is not out yet. So that's the procedure. You have to basically take the exam, and then you become a patent agent, and you can practice as patent agent. But if you want to really build an IP career in IP, you have to learn from scratch. It's like any legal work or any professional, like becoming a CA, for example, right? So you work with seniors, you grow up the ladder, you put yourself in as many different cases as you can, different scenarios as you can, different challenges as you can, and try to learn and you need to have good communication skills as well. You should not be afraid of asking ridiculous questions, to be honest. Okay, so that will help you get the client's inventions and technology in rather better way. Okay, so you look for an internship in some law firm or some IP firm accordingly.
Thank you. Yes.
Okay, mail address is being asked. Let me put here. I think Sudeep will also put it. Let me just also put on the chat window so that it's easy. Okay, you can just reach. I've left on the chat window, Prof. These details. I think Sudeep will also email the details.
Right.
Any other questions? I hope it's so the sessions today was about knowing the patentability assessment, and so I think it's quite a unique session I've done. Usually the sessions we do is on general knowledge of IP, etc. But this was quite deep and quite technical as well. Okay, so thanks Goa State Innovation Council, and thanks Sudeep for organizing it. If you have any inquiries, feel free to write to me or Sudeep, and we will solve them via email as well.
Thank you so much. Thank you, Rahul.
Thank you so much, Rahul. It was a wonderful session indeed, and I hope that with the all with the participation and the participants, with so many questions asked, I'm sure that everybody would have benefited out of this session. And a big thanks to all our participants for coming up in good numbers today and making this session a wonderful session. If you have any queries, questions, and all, you can reach out to us. Rahul has mentioned his email contact number over there. And also, our email ID is accessible, and soon we'll be sending a feedback form with all the rest of the required information. Please fill the feedback form and let us know how was the session and what else can be done in the domain of IPR. Thank you so much. Have a wonderful day. Thank you, Rahul. Thank you, everybody.
Thank you. Have a nice weekend.